secure to all in respect of the protection of human rights, conservation of human rights, promotion of human rights, and so on and so forth. See, therefore, human beings, basically they possess certain inalienable rights from their birth. Basically, they possess the inalienable rights from their birth. So from the birth itself, human being starts enjoying certain rights. Please remember, there are certain rights which are accrued to the individuals right from the birth is not given by any statute. They are not given by any law or enactment or constitution. They were endowed by nature. So therefore, we have to respect for nature. We have to worship nature, and we have to protect the nature. Since nature has provided innumerable, inalienable human rights. When I said human rights, what are these human rights? Are there any specific definition given by any agency or any human rights activities or anywhere in the world? It is very difficult to precisely define the term human rights. The reason is that every country whose ideology, whose culture, whose traditions, whose practices, they are different. So therefore, with this different in cultural factors, different in ideological factors, different in socio and economic conditions of each state, it is not easy to define universally what amounts to human rights. But an attempt has been made by many international leaders to explain and to observe what amounts to human rights. I always remember the words spoken by our former Secretary General of United Nations Organization, Boutros Ghali, wherein he says, human rights constitute a common language of humanity. Human rights constitute a common language of humanity. It is applicable to all human beings across the globe, irrespective of the territory, irrespective of the nationality, irrespective of the caste, irrespective of the sex, and irrespective of culture. These human rights, they constitute a common language of humanity. Our Protection of Human Rights Act 1993, it also in fact provides for what constitutes human rights. Human rights, according to Human Rights Protection of Human Rights Act 1993, it says human rights means rights relating to life, liberty, equality, and dignity of all individuals, which are guaranteed by the Constitution, or they are embodied or stipulated in an international conventions which are enforceable by court of law. So therefore, the human rights need not be in fact stipulated or encapsulated in the legislations or conventions. It could be even embodied in international conventions, declarations, international law, can also be in fact called as human rights. Therefore, fundamentally, human rights, it speaks about the dignity of human beings. Once the dignity of human being is ensured, then human beings can live happily in the society. Therefore, the United Nations Charter, even in its preamble, also in fact, it expresses that to determine and to reaffirm the faith and fundamental human rights. So in order to reaffirm as well as in order to have faith in the fundamental human rights, the UN Charter also in fact in its preamble expresses the determination, that is expresses is a commitment towards securing and reaffirming the faith in the fundamental human rights. So therefore, the concept of fundamental right is not confined to regionally, locally, nationally, but it has extended its tentacles even to the whole world, even to the whole cosmos. Yeah, people living across the globe, they can enjoy these human rights which are endowed by nature. See, when such being the case, when the human rights are endowed by nature, how man can take away these human rights? How man can violate these human rights? And how individuals can violate the human rights of others? It is very unfortunate that in this globalization, or even in the liberalization, or in the privatization policies, we do come across there are a lot of violation of human rights. Human rights violation not only takes place at the national level, even at the international level also. Whenever there is a war between two states, whenever there is a terrorism takes place, there we find the violation of human rights. The innocent people are become the scapegoats. The innocent people, they are the targets of this terrorist. So therefore, human rights assumed a greater significance at the global level in the recent past, in the recent decades. So what is to be done? How to protect our human rights? How to ensure human rights for all individuals? See, you know that people are living in the state of dichotomy. Whatever may be the society, whether it is a Western society or Eastern society, whether under the Western culture or Eastern culture, people are living in a dichotomy. What is the dichotomy? Dichotomy between the rich and the poor. Dichotomy between the vice and virtue. Dichotomy between the men and women. A dichotomy between minorities and majorities. See, therefore, when we are living with this dichotomy society, there ought to be an infringement of our rights, our infringement of our human rights. Why we call certain rights as human rights is for the simple reason that they are ensuring dignity to human beings. When these rights are ensuring dignity to human beings, they are called as human rights. For example, right to live, right to life, right to liberty, right to equality, and above all, right to dignity. See, all these rights, they are encapsulated under the various constitution much later. And for the first time, the American Constitution has given a constitutional status to these inalienable rights or natural rights into a constitutional rights. And then onwards, the various constitutions, they have also recognized these human rights or natural rights as constitutional rights. When we have these constitutional rights under the various constitutions, there is a need to protect these fundamental rights or constitutional rights. Sometimes I told you these human rights are also called as fundamental rights because they are fundamental for living. So they are fundamental for living as human beings, living with human dignity. Therefore, there is a need to conserve, protect our human rights. See, human right has got different dimensions. Human right, it is not only confined to human life, human liberty, human dignity, even the various other components, which are responsible for having a decent life, responsibility to have the liberty, responsibility for enjoyment of the dignity of individuals, they are also called as human rights. For example, right to have pollution-free environment. Right to have a clean environment is also a fundamental right, is a human right, which is also called as a fundamental right. See, therefore, there is a need to protect these fundamental rights from all kinds of exploitation, from all kinds of infringement. how to protect these these human rights, or which are also called as fundamental rights under the Constitution of India, or even under the international declarations. For example, Article 13, Class 1 of the United Nations Charter. One of the functions of the General Assembly contemplated under Article 13, Subclass 1 is to give assistance to the realization of human rights. To give assistance to the realization of human rights and fundamental freedoms for all. So therefore, this realization of human rights and fundamental freedoms, it must be ensured to all individuals across the globe without any distinction, or without having any consideration to religion, race, sex, language, and territorial limitations or national limitations. If this is the importance of human rights, then the larger question which comes up before us is how to ensure human rights without being infringed, or how to enforce human rights against the state action or even against an individual action also. Please remember, basically, human rights is, as Boutros Ghali said, human rights is a common language of the community. Human rights is a common language of community. Every community should be given an opportunity to enjoy these human rights which are endowed by nature. Now, the next parameter for the protection of human rights is there are certain mechanisms. Justice V.R. Krishna Iyer, in one of his judgments, Mumbai Kamagar Sabha case, he said, the mere enumeration of rights in the Constitution is not suffice unless and until people must be made to have access to these human rights and enjoy them. If the people are not having any access to these human rights or constitutional rights to enjoy, then there is no meaning for just enumeration of human rights in the Constitution as a fundamental rights. So that is to say, the mere encapsulation of these fundamental rights in the Constitution of India is not suffice unless and until there has to be a mechanism. There has to be a mechanism to see that these human rights are to be enjoyed by all, even the last man in the social order. Even the last man in the social order must be able to enjoy these human rights. Otherwise, there is no meaning for human rights at all. So therefore, according to V.R. Krishna Iyer, he says human rights, in fact, they are the rights which needs to be protected from all kinds of infringement and all kinds of exploitation. Therefore, the three justices in India, Justice V.R. Krishna Iyer, Justice Chandrachud, and Justice Bhagavati, they are the three important justices who have sowed the seed of public interest litigation. Remember, public interest litigation is nothing but a mechanism. It is a device for securing justice through public participation in judicial review of administrative action. There is a public participation. Public interest litigation involves a public participation in the judicial review of administrative action. If the people are not having any opportunity to participate in the judicial review of public participation or administrative actions, then there is no meaning for your human rights. So therefore, in India, the introduction of the concept of public interest litigation or a doctrine of public interest litigation is a revolutionary innovation made by these justices, through which justice is reaching to the doors of common sections of the society. is a great revolutionary innovation. We have never seen in any country across the globe. Through your public interest litigation, you can reach down to the common sections of the society. You can take your social justice to the common doors of the society. So therefore, public interest litigation is an interest which is shared by citizens generally. For example, there are certain issues which are commonly shared by individuals. It is not the property of one individual. It is not the right of one individual, but it is the right of common people or a community or a group of people. For example, environment. The right to environment is a right which is given to the community at large. If an environment is degraded, if an environment is polluted by the state action or even an individual action, you can proceed against them because you have a human right. The human right, that is your right to have pollution-free environment, is an integral part of human right. So if you do not have a clean environment, if you do not have a pollution-free environment, and your other rights, your other human rights like right to life, right to liberty, right to equality, right to dignity, to live with human dignity, I think has no meaning at all. So therefore, environment should be also considered as a human right, which is an integral part for the sustainability of human beings. And of course, for the first time in the year 1991, the Supreme Court in Subhash Kumar versus State of Bihar. In 1991, AR Supreme Court, the Supreme Court said in Subhash Kumar versus State of Bihar, right to life and under the Article 21 of the Constitution as a fundamental right, which includes right to enjoyment of pollution-free environment. So Article 21 of the Indian Constitution, it speaks about right to life and personal liberty. But the Supreme Court interpreted and said right to life as a fundamental right also includes right to have enjoyment of pollution-free of water, pollution-free of air, pollution-free of environment. If the pollution-free environment is not ensured by the state, then you can enforce it as a human right, because this environment, pollution-free environment, is very much required. It is inevitable for human beings. It is inevitable for all human beings to live with human dignity, to live with proper health. So therefore, in order to have a healthy society, in order to have a proper health, there is a need to ensure pollution-free environment. So therefore, today, pollution-free environment is also come within the purview of the human right. Therefore, if anything endangers or if anything impairs the quality of life, a citizen has a right to have recourse to Article 32 and 226 of the Indian Constitution. Suppose if anything endangers or impairs the quality of life through the action of the state, then under such circumstances, every citizen has a fundamental right under Article 32 to invoke the extraordinary jurisdiction of the Supreme Court as a fundamental right. It can invoke the jurisdiction and it can enforce your fundamental right to have pollution-free environment, because it is a human being, it's a human right. And also Article 226, every citizen, once his right to environment is violated, he can also invoke the extraordinary writ jurisdiction of the high courts under Article 226 of the Indian Constitution. So therefore, these are all the two mechanisms through which, the constitutional mechanisms through which you can ensure your human rights wherever they are violated by the state actions or by any individuals. Remember, before going to the public interest litigation, before the introduction of public interest litigation, we had a locus standi. we had a principle of locus standi. Earlier, before 1976, before the introduction of this doctrine of public interest litigation, there existed doctrine of locus standi. What is this doctrine of locus standi? Doctrine of locus standi, it says whoever's rights are injured or whoever receives any legal injury shall only in fact approach the court for redressal of their grievances. And persons who have not received any legal injury have no right to make an application on behalf of the person who has received the legal injury under this rule of locus standi. So therefore, under the rule of locus standi, only the persons who have received the legal injury, whose fundamental rights are violated, whose human rights are violated, they can only approach the court. They can only make an application, a writ petition, invoking the extraordinary jurisdiction of the Supreme Court as well as the High Court. No other person can move the Supreme Court or High Court on behalf of the injured person. But with the introduction of public interest litigation, thanks to our Indian judiciary for the recognition of the mechanism of public interest litigation. In the case of public interest litigation, any public having bona fide intention, any public having public spirit to protect the interest of others can also make a petition before the writ courts for issuing appropriate writs for the protection of human rights. For the protection of human rights. Remember, there are two ways in which public interest litigation can be moved in the writ courts. In India, there are only two courts having the jurisdiction to issue the writs. One is Supreme Court under Article 32 and High Courts under Article 226 of the Indian Constitution. In order to move the public interest litigation, there are two ways in which public interest litigation can be moved in these courts. The first is adversarial jurisdiction. Public interest litigation can be moved through adversarial jurisdiction, and the second one is epistolary jurisdiction. Advisory jurisdiction means only the person whose human rights are violated can directly approach the court by making a writ petition, by filing a writ petition. He has to pay the court fees, he has to engage a lawyer, and he has to pay the required court fee and register his petition. This is a formal way of filing a writ petition, is what is called as adversarial jurisdiction. But there is another jurisdiction through which a public interest litigation can also be moved in the High Court and Supreme Court. That is epistolary jurisdiction. Epistolary jurisdiction means the person whose human rights are violated need not directly go to the court. He can just write a letter to the appropriate authority of the Supreme Court or High Court. That is the registrar. He can write a letter, he can send a telegram, he can send a fax, he can send email, he can send information through mobile for seeking the judicial redress by highlighting the nature of the violation of human rights, the place in which the violation takes place, the person who are responsible for violation of human rights, all these informations and the remedy sought, all this information must be given to the appropriate authority through the mechanism of letters. You can simply write a letter. Today, you have mobiles. You can send messages. You can even call directly to the authorities. This is what is called epistolary jurisdiction. You may ask me a question: why this epistolary jurisdiction has been identified or has been recognized? Friends, remember, millions and millions of people in this country, they are not able to enjoy their constitutional rights as well as human rights. These people they have no economic stability. They have no ability to approach the court for enforcing their rights because of technicalities like poverty, penury, illiteracy, ignorance. All these, in fact, are responsible for these people, preventing them from approaching the court for the redressal of their grievances. Therefore, V.R. Krishna here says the constitutional human rights, which are given to all citizens of this country, should not be merely a farce. It should not be a distant dream for the poorer sections of the society. Even the poorest of the poor in our society must be able to enjoy the constitutional benefits. In order to make them to enjoy the constitutional benefits, we need to provide a mechanism so that through that mechanism, they can enjoy all the human rights which are given, and not only under the Indian Constitution, but also under the international conventions and international declarations. So therefore, public interest litigation has been recognized or promoted by justice. Through public interest litigation, now any public spirited person, any public organization, or any public having bona fide intention can move the petition on behalf of the aggrieved party, on behalf of the person whose human rights have been violated. There are millions and millions of instances, especially human rights are getting violated, human rights are getting infringed in various industries, in various industrial sectors, in various stone quarries, mining operations, even in various educational institutions. There is no place you find where there is no violation of human rights. Across human rights are also being violated, not only inside in India, but also outside India. And much of the violation of taking place, they are found in the industries, mining operations, or even police stations, then prisons. These are all the places where you do come across the gross violation of human rights. Let me take up a few decided, celebrated decisions of the Supreme Court in ensuring human rights through public interest litigation. Firstly, in People's Union for Democratic Rights versus Union of India, People's Union for Democratic Rights versus Union of India in the year 1982, which is also popularly called as Asiad Project case. You know that when the Asiad Games was taking place in India, many projects were proposed by the central government for the construction of buildings, for the construction of cafeterias, for the construction of the various sports fields for conducting the Asiad Games. And therefore, the central government, what they did was, they brought more than 15,000 workers to work in these Asiad projects, and they brought from Karnataka, Andhra, Kerala, Maharashtra. From all the 4 southern states, they brought the workers to work in the Asiad project. When they were recruited, or when they were appointed as to work in the Asiad project, they were fixed minimum wages. Even though minimum wages was fixed for them, the intermediaries, that is the intermediary contractors through them the workers are working, these contractors, in fact, they deducted 3 to 4% of their minimum wages, and also these workers were not provided with any protective devices while they were working in various dangerous projects. They were also not provided the minimum wages because 3 to 4% was deducted by the contractors while giving the payments every month. At the same time, these workers were also not provided any medical facilities whenever they are exposed to danger. When that being the case, this matter was taken up by the public organization called People's Union for Democratic Rights. People's Union for Democratic Rights is a public organization, filed a public interest litigation before the Supreme Court, highlighting the pathetic condition in which these workers were made to work by these contractors. The Supreme Court, having realized the pathetic conditions which were exposed by the People's Union for Democratic Rights, the Supreme Court issued the direction to central government to see that all the workers working in the Asia projects, they must be ensured adequate protection, adequate safety and security, and all the environmental laws must be implemented, and even the laws relating to the minimum wages should be secured. So therefore, Supreme Court issued series of direction to the Union government based upon the public interest litigation filed by the public organization called People's Union for Democratic Rights. See, this was possible only because of the mechanism of public interest litigation. Otherwise, who would have helped these 25,000 workers who are subjected to work just like as slaves without giving adequate protection or adequate safety? Likewise, in the year 1984, the Supreme Court, in fact, also gave a very interesting decision in Bandhwa Mukti Morcha versus Union of India. Bandhwa Mukti Morcha versus Union of India in the year 1984. See, this is a case basically relating to stone quarry case. You know that in this case, what happened? There were many stone quarries which existed in the Faridabad place, where stone quarries were taking place, in which laborers were employed in these quarries, stone quarries, and they were made to work nearly 150 meters below the earth. 100 meters below the earth, they were made to work in various stone quarries. While they were working, there were many accidents. That is, when the stones were blasted through dynamite, the pieces of stones, in fact, they used to hit some of the workers, and the workers, in fact, they were injured. When they were injured, the Union government had not made any arrangement for providing immediate medical care. Even the contractors who are acting as a representative of the central government, they were not taking care of these workers working in these mining operations, stone quarry operations. So therefore, since these workers were frequently exposed to the fatal accidents or fatal incidences, they were in fact getting affected. The matter was taken up by the Bandhwa Mukta Morcha, again a public organization which filed a public interest litigation before the Supreme Court. Now the Supreme Court, after filing the petition, it constituted a commission. A commission was constituted, and the commission was sent to the Faridabad stone quarries to make an investigation and report back to the Supreme Court. A report was given by the commission, and in the report, the plight of the workers was very much explained by the commission. They said these workers working in the stone quarries, they had no medical facilities, they had no compensation. That means whenever they are affected and whenever they are injured, or some workers when they die, there is no compensation facility provided, and middlemen were extracting the wages from the poor miners. When taking into consideration all these, the Supreme Court, in fact, issued a stringent notice to the central government to see that all these laborers were called as bonded laborers because they were not left. These laborers, even after the tenure is over, because they were brought for a period of say 8 months or 1 year, but even after that they were not allowed. And therefore the Supreme Court said they were all bonded laborers, and immediately the bonded laborers must be released forthwith, and they should be placed in a better positions, and by providing all adequate measures. And the direction was also issued to the central government to implement all industrial laws for the protection and safeguarding the interest of minors. Remember, for the first time, the Supreme Court, as a result of public interest litigation filed by this Bandhu Mukta Morcha, the court said right to life under Article 21, which is guaranteed as a fundamental right, it goes along with right to human dignity. What kind of human dignity is being ensured by the government to these miners who are working in these mining operations, stone quarries? So therefore, the court said right to life includes right to live with human dignity free from all kinds of exploitation. They should be ensured human dignity free from all kinds of exploitation. That is the constitutional mandate. That is the constitutional mandate under Article 23 of the Indian Constitution as well as 21 of the Indian Constitution. So that is how the Supreme Court, in fact, took cognizance of the plight of these workers through public interest litigation. Please remember, public interest litigation is not only being used in the area of industries or in the area of industrial establishments, but even in the area of environment also, the public interest litigations are being used. For example, in Ratlam Municipal Council versus Vardichan, what happened was, the commissioner of the Ratlam Municipal Council, the successive commissioner for nearly 25 years, successive commissioners, they had not taken the project for providing drainage for the residents of the Ratlam Municipal Council. There was no drainage system at all for the past 2.5 decades. As a result of which, thousands and thousands of the residents of this Ratlam Municipal Council, they were infected with many diseases. Some of the people who are living within this area, that is the area of Ratlam Municipal Council, they were infected with dermatitis, lung cancer. Some of them, in fact, they died as a result of the pollution of environment in the absence of drainage system, underground drainage system. And this was challenged before the Supreme Court through a public interest litigation by Vardichan. When the public interest litigation was filed, the court summoned the commissioner of the Ratlam Municipal Council to explain why they have not taken initiative in providing drainage system. Do you remember? The very interesting argument made by the commissioner was that the Ratlam Municipal Council for the past 25 years has not taken any initiative for providing drainage system, underground drainage system, is for lack of economic stability. Government has not provided any grants for undertaking this drainage system. Therefore, we have not been able to provide drainage system for the residents of Ratlam Municipal Council. But the Supreme Court struck down the contention and said, no environmental law can be violated. No environmental law can be violated on the ground of economic instability. And the court said, economic instability is not a criteria for violation of fundamental right. Economic criteria is not a violation for fundamental right. Tomorrow, Tomorrow, a municipal council or a municipal corporation or a municipal authority may say, since there is no grant, we are not able to saturate the pollution of environment, saturate the pollution of water or pollution of air. They cannot plead so. It is the duty of the state, whatever may be the means, it should be the duty of the state to ensure the pollution-free environment for all the citizens. Otherwise, it's a violation of human rights. It's a violation of human rights for which every individual has a right to proceed against such authority, which is ignorant in ensuring human rights. There is another interesting area, that is medical jurisprudence. Look at the medical jurisprudence. Even in the area of medical jurisprudence, the role of public interest litigation is very important. It has assumed a significant role even in ensuring medical care facilities. You may be remembering the one Paramananda Katara versus Union of India. Case which came before the Supreme Court in the year 1989, wherein the Supreme Court said, if any medical institution or medical hospitals, be it a government medical hospital or private medical hospital, if any medical institution or medical practitioner refuses to provide medical emergency treatment to an ailing patient, then it is a gross violation of human rights. See, Paramananda Katara, he was a public spirited person, filed a public interest litigation against the union government because the central government hospitals, they had not provided medical facilities, emergency medical facilities for a boy who sustained injuries as a result of the accident which took place. The boy was not given medical treatment, immediate medical treatment. When the boy was not given medical treatment by many central government hospitals, a public interest litigation was filed by Paramananda Katara, a public spirited person, saying that there is a gross violation of human rights where there is a denial of the medical care. If the medical care is not provided or the emergency medical treatment is not provided, then it is a violation of human dignity and it's a violation of human rights. For the first time, the Supreme Court, after having considered the public interest litigation filed by Paramananda Katara, said, right to life under Article 21 includes not only it not only includes the mere animal existence, but it also includes right to have emergency medical treatment. Right to have emergency medical treatment is also a fundamental right and also a human right. If any medical institution in India today, or if any medical practitioner, whether he is a private practitioner or a public practitioner, if he refuses to provide medical treatment for an ailing patient, when a patient is almost in the deathbed, then such hospitals and such practitioners, medical practitioner, shall be prosecuted under the Indian Penal Code, and also there against them the prosecution initiation shall also be initiated, because right to life under Article 21 includes right to have emergency medical treatment. Therefore, the role of public interest litigation has gone to such an extent that even the poorest of the poor man, if he is injured in any accident and denied any medical treatment in any hospital, he can also have a fundamental human right to ask for emergency medical treatment. Suppose the poor man is not able to challenge it before the court, then through public interest litigation, any public on behalf of the poor people can approach the court and for redressal of their grievances. Redressal of their grievances. Look at the role of public interest litigation in securing human rights of prisoners. Human rights of prisoners. Look at the role of public interest litigation. Role of public interest litigation. For example, for the first time, the Supreme Court accepted and recognized the public interest litigations filed by the public organizations for the speedy disposal of the cases, for the speedy trial. For the speedy trial. What is this speedy trial? Remember, according to Kiran Bedi, the then DGP, she has given a report to the central government wherein she says 73% of the prison population in this country, 73% prison population in this country, they are all under trial prisoners. They are all under trial prisoners. That is, they are all waiting for the trials to start. They have been sent to the judicial custody for a long time. They have been there for a long years. Maybe some of them, they are 7 years, 8 years. Some of the prisoners, they are still in the jail for 15 years, but no trial has started. No trial has been conducted. They are called as under trial prisoners, waiting for the trial to start. When they are waiting for the trial to start, where trial has not been conducted, don't you think that their human rights, basic human rights like right to live with their family, right to live with the society, right to meet their friends and relatives, right to have dignity, are they not violated if the trial is not conducted? Unnecessarily keeping the prisoners in the prison without conducting the trial. The Supreme Court, for the first time, taking into cognizance the public interest litigation filed by the petitioner, the Supreme Court said every prisoner in India has a fundamental right to speedy trial. Right to life under Article 21 includes right to have speedy trial. What kind of life we are talking about under the Constitution of India? What kind of dignity we are talking about under Article 21 of the Indian Constitution? If the prisoners are not, in fact, subjected to trial, immediate trial. I'll give an example. Assume that a person is arrested for a small wrongful act. Suppose his wrongful act is proved in the court, he may be given 3 months imprisonment. That's all. The law says he may be given 3 months imprisonment. But remember, they are such kind of people, they are kept in the prison for more than 10 to 12 years because trial has not been conducted. If the trial is conducted, they would be immediately released because they've already spent more than what the punishment is there under the Indian Penal Code. So therefore, the Supreme Court issued direction to all the chief secretaries of the India, all the chief secretaries of all the states in India, to see that whoever prisoner has spent already more time than the punishment if the case is proved against him, such people should be released immediately because they have a fundamental right to live as human beings, right to live with human dignities. And therefore, by recognizing the public interest litigation, the Supreme Court said a right to life under Article 21 means a right to live with human dignity along with right to speedy trial. Every prisoner can ask for speedy trial. If the speedy trial is not conducted, then their fundamental right to dignity, life and dignity is violated. That is why the role of public interest litigation assumed a greater significance. Right against torture. You may be surprised to know that in most of the police stations, when the accused are arrested, they are kept in the police station without producing before the court. Even though constitutional mandate is that, even the constitutional right is that, as soon as the person is arrested, he shall be produced nearest magistrate within 24 hours. Many accused persons or many arrested persons, they are not produced. Sometimes they are kept in the police station for more than 24 hours. And sometimes there is a torture also. They are subjected to third-degree punishments in the police stations. See, therefore, in Sunil Batra versus the Delhi administration, for the first time, Sunil Batra, a fellow prisoner, he filed a public interest litigation through his friend, highlighting the torture given to his fellow prisoner by the jail authorities. When the public interest litigation was filed, the public interest litigation was converted into a regular writ petition under Article 32 by the Supreme Court. It converted the PIL into a regular petition under Article 32 and issued direction to the Delhi administration to see that there shall be no torture. There shall be no torture against any prisoner who is in the prison, whether he is an under trial prisoner or whether he is an offender or whether he is a convict. Irrespective of the nature of the offense, there shall be no torture in the prison. That is why, for the first time, the court recognized an unrecognized right. Under the Constitution of India, there is no fundamental right against torture. There is no fundamental right against speedy trial, right to speedy trial. There is no fundamental right against solitary confinement. Remember, all these fundamental rights, today they are recognized by the Supreme Court as an integral part of human rights. There are no rights. Constitutional Article 1, it only says, state there no person shall be deprived of his life or personal liberty, except the procedure establishment. There is no right to speedy trial. There is no right against torture, but it is because of the recognition of the public interest litigation by the Supreme Court and various high courts. Today, right to speedy trial is also recognized as a fundamental right or a human right. No human being shall be subjected to torture. No human being shall be subjected to many years no human being shall be kept under the prison for many years, and no individual shall be kept under the prison in a solitary confinement. See, where individuals are kept under solitary confinement in the prisons, public interest litigation can be filed. Every prisoner has a fundamental right and a fundamental human right against solitary confinement. What is the fundamental principle of criminal justice system in respect of prisoner? The fundamental principle of criminal justice system is that every prisoner shall be subjected to reformation. Just because he is a prisoner, he shall not be considered as a convict. He shall not be kept under solitary confinement. If you keep any prisoner in a solitary confinement, then at one point of time, the prisoner, he will go mad. So, making the prisoner a mad is not the fundamental principle of criminal justice system. The fundamental principle of criminal justice system is to reform the criminals and not to make him mad by keeping in solitary confinement. And therefore, the Supreme Court said solitary confinement is against to human rights. It is against to fundamental right of Article 21 of the Indian Constitution. So therefore, Article 21, it also includes right against solitary confinement. Right against solitary confinement. Today, we are all witnessing that many arrested people are brought to the court, nearest court, for trial, by using the shackles, by using the handcuffs. While using the handcuffs, if the arrested persons are brought before the court said, using the shackles or using the handcuffs, it violates the dignity of the individual. Whether he's a accused person, whether he's a wrongdoer, whether he's a criminal, whatever it may be, using the handcuffs or shackles and bringing the accused before the court with the shackles or handcuffs is nothing but violation of their human dignity and human right. But does it mean that they should be free? Even the handcuffs should not be used for these people while bringing them to the court? No. The court said you can use these handcuffs and shackles while bringing them to the trial only with the prior approval of the court, only with the prior permission of the court. If the court's permission is not there, then using of shackles or handcuffs to bring the accused before the court is nothing but the violation of human dignity and human rights. So therefore, for the first time, the Supreme Court, taking into cognizance of the public interest litigation filed by the petitioner, said right to life includes right against handcuffing. Right against handcuffing. Then right to have free legal aid. See, today, the accused persons, when they are brought before the court, if they happen to be poor people, if they happen to be people have no background, economically unstable, and they are not able to engage a lawyer, for them, the justice should not be a dream. For them, justice should not be denied. For them also, justice should be provided because Constitution has ensured human rights or fundamental rights to all, irrespective of the richness, irrespective of the poor, or irrespective of the rich people. So therefore, the Supreme Court said, yeah, it is the duty of every court, trial court, to ensure free legal aid for those individuals who are not able to engage their lawyer for their defense. See, this was possible only with the public interest litigation. The public interest litigation filed by the petitioner questioning the very validity of the trial court not providing free legal aid. I'll give you an example. A person is arrested and brought before the court for trial. The judge said, whether have you brought any lawyer, advocate to defend you? And the poor accused says, no, sir, because I am a poor man, I cannot engage a lawyer. And therefore, I don't have any lawyer. If that is the case, the court says, the judge says, if that is the case, you will be remanded to judicial custody. Why? Because you have no individual, no person to represent you. So they are remanded to judicial custody. After remanding judicial custody, they are kept in the judicial custody as under trial prisoner for many years without conducting trials. Supreme Court said, this is violation of human right. This is a gross violation of human right because the state should have provided free legal aid services to such accused persons who are unable to engage their lawyer. Because of their economic poverty, social and economic poverty, if they are not able to engage the lawyer, they must be provided free legal aid. So therefore, these are all the rights recognized by the Supreme Court in favor of the prisoner as a result of public interest litigation. If the public interest litigation mechanism has not been invented or not been introduced in India, probably thousands and thousands of prisoners, they were left without any remedy. They would have completely spent their whole life in the prison only, even without conducting inquiry or without conducting trial. It is because of the mechanism of public interest litigation enunciated by three justices, Justice Krishnaya, Justice Chandrachud, Justice Bhagavati. Today, millions and millions of prisoners, they are taking shelter under public interest litigation, and getting justice. Remember, public interest litigation has also, in fact, protected the interest of the hawkers, the traders, the petty businessmen, and even the vulnerable sections of the society. The best example I can quote is the decision of the Supreme Court in Volga Tellis versus Bombay Municipal Corporation. Volga Tellis versus Bombay Municipal Corporation is a very interesting case where the Volga Tellis is a public spirited organization which took up the cause of payment dwellers. Payment dwellers are those small petty business people. They're all hawkers. They were undertaking this small business on the footpath of the Bombay city. When they nearly 25 to 27,000 the payment dwellers, they are living on the footpath by carrying on small petty business. Their livelihood is depending upon their petty business. One fine day, the corporation commissioner, that is the Bombay Municipal Corporation commissioner, he took a unanimous decision to evacuate all these 25,000 payment dwellers from their respective places. When they were evacuated, a public interest litigation was filed by a public organization called Volga Tellis. Volga Tellis took the cause of these individuals, these 25,000 hawkers, before the Supreme Court. The Supreme Court said, evacuation, that is removing of all these 25,000 hawkers or payment dwellers from the respective places, it is a violation, gross violation of human dignity as well as human right. In this case, the Supreme Court said right to life under Article 21 means and includes right to livelihood. So every individual in this country has a right to livelihood as a fundamental right recognized under Article 21 of the Indian Constitution. Remember, this decision was given by the Supreme Court as a result of the recognition of the rights of these people through public interest litigation. If the public interest litigation mechanism had not been introduced, probably these hawkers or payment dwellers would have been stranded. They would have left without any justice. See, therefore, as a result of this public interest litigation, these payment dwellers, in fact, they were protected by the Supreme Court. Directions were issued to the Bombay Municipal Corporation to provide alternative arrangements for these payment dwellers. Otherwise, it's a violation of their human rights or human dignity. But there are certain limitations. Public interest litigation, no doubt, it's a strong weapon. It's a strong mechanism which takes the social justice to the doors of the common people, or doors of the common section of the society. On the other hand, if there is an abuse of public interest litigation by the people, then the court has also, in fact, laid down certain principles. There are certain limitations for the use of public interest litigation for ensuring human rights. For example, any public interest litigation filed by any public spirited person or public organization or public associations with a bona fide intention. Public interest litigation shall be filed with bona fide intention. If there is no bona fide intention in the public interest litigation, but where there is only a personal interest, then the court can decline to recognize such public interest litigation, and also it can impose even penalty for such individuals. You may be remembering that there are many instances where courts have imposed exorbitant penalty for any trivial public interest litigation. If a public interest litigation is filed for a trivial purpose, a small cause, without having any rationality, then under such circumstances, the courts, both the Supreme Court and High Courts, in several circumstances, have imposed penalty for the petitioner. So therefore, public interest litigation, it must be filed with a bona fide intention, not with a mala fide intention. Number one. Number two, court should not allow the process to be abused by the politicians. Many times the politicians will make use of this public interest litigation, challenging the validity of the election results. As soon as a result is out, as soon as the result is released, election result is released, the defeated candidate immediately, in fact, he will file a public interest litigation against the election commission, saying that the elections are not conducted properly. Remember, the court said no such incident, no such a process should be allowed to be abused by the politicians. Court should not allow this kind of process to be abused by the politicians or to gain political or ulterior objectives. Some people, they file the public interest litigation not for the securing human rights, not for the protection of human rights, but for the protection of their own ulterior objective or ulterior motive. See, under such circumstances, the limitation is that no court shall entertain such petitions which is abused by politicians for their politicians or any individual for their personal gain. So these are all the limitations for public interest litigations. I think I'll stop here. I want some observation from you, and any questions from your side, I would like to respond. Yes, Prashant, tell me. Any questions or any observations?
It was very good, sir. It was nice presentation. Nothing more.
Any questions to be asked?
Nothing,
sir,
sir.
interesting.
Clear, sir. It's clear, sir.
Sir,
Ah,
it's an interesting talk, sir. May I know how long this PAL takes normally?
Normally, PL, if it is in the form of epistolary jurisdiction, it will take not less than 6 months. If it is adversarial jurisdiction, it might take at the most 3 to 4 months. Again, public interest litigation, recognition of public interest litigation, and accepting this public interest litigation as a writ petition under Article 32-26, depending upon the discretionary of the court. Again, it is depending upon the discretion of the court. You cannot insist the court to immediately, today only you should take cognizance and tomorrow you can issue the orders. No. Sometimes what happens, through public interest litigation, you can get some interim relief also. Some interim relief can be provided immediately, pending the final disposal of the case.
Thank you, sir.
Yeah.
And even it depends on subjects also, sir.
It all depends upon it all depends upon the gravity
Subject
and the
and
intensity
cases.
of the subject.
Yes, sir. Yes, sir.
Gravity and intensity of the subject. Correct.
Good morning, sir.
Good morning. Who are?
Sir, Lalita Bai from Holenasipura, sir.
Oh, Lalita Bai. Tell me, Lalita Bai.
Yes, sir. Sir, one question. ಈಗ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಎಲ್ಲ ಇದ್ರೂ ಕೂಡ ಈ ವಿಕ್ಟಿಮ್ಸ್ ರೈಟ್ ಅನ್ನ ತುಂಬಾ ವೈಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಡಾಕ್ಟರ್ಸ್ ಮೆಡಿಕಲ್ ಇದರಲ್ಲಿ. ಈಗ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು, ಇಲ್ಲೆಲ್ ಪರ್ಸನ್ ತುಂಬಾನೇ ಅವನು ಸೀರಿಯಸ್ ಆಗಿದೆ ಅಂದ್ರೂ ಕೂಡ ಪೊಲೀಸ್ ಬಂದು ಅದನ್ನ ಏನೋ ಮಾಜರ್ ಮಾಡೋರ್ಗು ಪೊಲೀಸ್ ಎನ್ಕ್ವೈರಿ ಮಾಡೋರ್ಗು
ಇಲ್ಲ. ನಿಮ್ಗೆ ಪರಮಾನಂದ ಕಟಾರ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರದಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಹೇಳಿದ್ದಾರೆ. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತಂದ್ರೆ, the saving of the life of an ailing patient is much more important than that of your all police procedures.
Yes, sir.
You don't go for the police procedure immediately.
Yeah,
they have excluded the police procedure. You can make the police procedures, all the mahjar and all that later, but what is required is that immediate medical treatment is to be provided. If there is a denial of immediate medical treatment, it also violates your gross violation of human right and fundamental right under Article 20.
Yes, sir.
ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಯಾರು ಇನ್ವೋಕ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಇದನ್ನ ಎನ್ಫೋರ್ಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Yes, yes, sir. Yes, sir.
Should enforce it.
Yes, sir.
Yeah.
Thank you, sir. Thank you very much, sir.
Thank you. Any other questions? No questions? Okay. If there is no questions, no problem. Thank you for all of you for participating in this online lecturing program. And I'm very happy to see my own students are there in representing from different colleges and various universities. I'm very happy, and I hope that at least something has gone to your mind, or some students have they are remembering my earlier lecture after having heard today's lecture. Thank you so much. Thank you.
Thank you very much, sir.
Sir, it's
Oh, thank you. Your name?